Good morning, good afternoon, or good evening. My name is Leonardo Lampret. I'm from the law office of Melissa Day, and today we're going to talk about the question I get asked very frequently: is there such a thing as a straight divisor when it comes to calculating average weekly wage? Now, many clients and many people come to me and ask me, Leah, why can't we just use a straight divisor to calculate average weekly wage? Wouldn't that be more representative? Wouldn't that be more logical? And as far as I agree with that, the short answer is no. So under the workers' compensation law, there is no such a thing as a straight divisor, at least not by default. Outside of situations where both parties stipulate to using a straight divisor to calculate the average weekly wage, the board has extremely narrow basis of doing so. The board has consistently held that, based on the statute, average weekly wage is calculated using multipliers, not a straight divisor. So in general, rule is that 260 multiplier is used when the claimant is a 5-day worker, 300 multiplier is used when a claimant is a 6-day worker, or a different multiplier if the claimant works some other schedule. However, the multiplier should not be less than 200. That's the statutory framework, and the board has been applying this religiously. However, courts have recognized an important principle through judicial precedent. Before a multiplier can be used, the claimant must have been fully available for employment before the injury. Please note that the carrier or self-insured employer has burden of proof to show that the claimant's employment before the accident was self-limiting, and therefore start developing on the record on the issue whether or not the multiplier or a divisor should be used. But going back to the point, the third department explained in Kalish versus Kalish Tire Sales that the 200 multiplier applies only if a part-time claimant was fully available for the employment, and it does not apply if the claimant voluntarily limited their availability. So the question comes now what? What happens if the claimant's job was actually self-limiting? Well, that's when the board may actually use a straight divisor. So, for example, let's go to some practice. In a case, employer Madison Oneida bosses with a WCB number G227-3590 from July 28, 2020, the claimant worked as a substitute teacher where she testified that she was only available to work 3 days a week. That was Tuesdays, Wednesdays, and Thursdays, and was not available to work on Mondays and Fridays because she was taking care of this family member. There was also no evidence on the record that the employer was closed on Mondays and Fridays, and based on the evidence on the record, the board found that she was not fully available for the employment, and therefore the board used a 52-week divisor because it most accurately reflected her annual earning capacity. So, long story short, no, straight divisor is not a rule, it's the exception to the rule. And the carrier or self-insured employer has a burden of proof that the claimant's employment was self-limiting. And it only applies when there is an evidence to support it. But if you do prevail, proving that the claimant's employment before the accident was self-limiting, that could potentially save you thousands of dollars in indemnity. Thank you very much for tuning in, and see you next month.